Mombasa.
What is wrong with Mombasa?
No, the High Court in Mombasa. That's what I meant.
Which specific high court? I mean, is it the Constitutional Court? That's what I'm asking. Mm-hmm. Okay.
Yeah, allow me to make an attempt. They tried at the Magistrates Court, not in the High Court.
Where are you?
What do you mean by where am I?
I mean, which part of Kenya are you? So that I can send a team.
To greet me.
Yes, wakusalimia vizuri sana. I have a reliable team waiting for instructions. Nikisema tu mwe, wewe umeisha. What do you mean? What do you mean by the Magistrate Court? All right, so let me answer that question quickly and so that we move. So we talked about the jurisdiction of courts and specifically the jurisdiction of the High Court. And during that time, we say that one of the special jurisdictions of the High Court is the question of admiralty. Okay, these are offenses that are committed at sea. Okay, now offenses are committed either on against the ship. You know, we have offenses against the ship. We have offenses against the people on board a ship. We have offenses against the property or the goods on board of a ship. So those are admiralty offenses, things like hijacking, piracy, and so on and so forth. Now, admiralty offenses are tried by the Admiralty Court, okay, which is a special branch of the High Court. Okay, so any offense that is committed at high seas, it is an admiralty offense, and therefore the High Court shall have jurisdiction to entertain that specific charge sheet. Tunasikizana? Isore?
Yes, thank you. I had another question.
Proceed.
My second question was on identification parade, and it asked rules governing identification obtained at night. Are there specific rules for those?
It's a clear thing. It's a clear thing in terms of the consideration we talked about. Okay, what is the question of lighting and the distance? We talked about that. So if you are going to because that question could be interpreted in two senses. The first sense is when ID parade is conducted at night. Okay, when ID parade is conducted at night, and then when identification, the commission, there are two types of identification here that you're talking about in terms of that question. Number one is the identification of the suspect by the victim during the commission of the offense. Okay, remember that when you are coming to identify somebody in court or to testify in court, essentially what you're saying is that I saw him. He was stealing and I saw him. So that is identification at the point of the commission of the offense. And then now we have the identification parade. Okay, there's no reason at all why ID parade should be conducted at night. Okay, there's no reason at all. There's no reason at all why it should be conducted at night. But if it is conducted at night, the same rules apply. Okay, whether it is conducted at night or not conducted at night, again, the same rules will apply. But of course, you'll have to modify your answer to make sure that it's making or it relates to an ID parade which is being conducted at night. For instance, you want to make sure that there's proper lighting in the first place, so that because it's at night, you don't have the benefit of the natural light, and therefore you want to make sure that this witness is clearly able to see the suspects on the line. Aside from that, just the question to do with the security of each person involved, because at night, the security of the witness and the suspects must also be guaranteed. But aside from that, all the rules of ID parade will follow. They're just the obvious rules of ID parade. All those will follow. But it's just a question of the lighting. But also remember that that question of lighting will also come in the instance of admission of this evidence of ID parade, whereby the court will want to establish whether indeed, okay, whether indeed this person was identified, considering the lighting during the commission of the offense, or the distance between the suspect and the witness during the commission of the offense. Are we together?
Yes, thank you.
All right. Swali nyingine ama nyingine. Swali nyingine. All right. I don't see any other question. Okay, Chumondi, what is your question?
Now, on that question of jurisdiction, good morning, good afternoon, good evening. On that question of jurisdiction, I have two questions. Assuming you board the Kenya Airways and you commit a crime inside Kenya Airways while you're in Dubai, or you board the Emirates flight and you commit a crime inside the Emirates flight while you're in Kenya or in another jurisdiction, or you commit a crime inside one of the embassies, say you're in Kenya, but then you go to the embassy of the United Arab Emirates and then you commit a crime in there. The presumption I normally have is that when you commit a crime inside, say, an embassy, then the laws of that country should apply. I needed your guidance on that line. Thank you.
All right. So there's something called the long arm. You know, it's called the long arm rule, or the long arm jurisdiction. I'm very sure you've heard about the long arm jurisdiction, but let's talk about now commission of crimes on air flight. I mean, on flights. Now you know that every country has got their airspace. So the moment the flight enters the space of another, then that specific country becomes criminally, or claims jurisdiction. Okay, so any offense that is committed on an airspace, okay, on an airspace belonging to a specific country. So if it is Kenyan airspace, okay, there's a way the guys they map it so that they know Kenyan airspace is from this place to this place. So if you commit a crime while in Dubai, then of course you are within the Dubai airspace, either on land or on air. Then generally they will take jurisdiction to prosecute you. By the fact that you've committed the offense on their land, they will prosecute you. However, remember what I've said about the long arm jurisdiction. What is the long arm jurisdiction? Now, give me 1 second. Guys, you guys are crazy. When I say time, you don't keep time. All right, so what is the long arm jurisdiction? Now, the long arm jurisdiction is simply a principle in law that allows a country to come and look for you. If you are a Kenyan, the long arm jurisdiction allows Kenya to come and look for you in the US, to bring you back home and punish you. It's like if you have a kid and you go visiting your relatives, Okay, you go visiting your relatives and this kid misbehaves, you'll not punish the kid there. You'll wait until you come back home, and that is when things will bite each other. So that long-arm jurisdiction says that anytime you are moving as a Kenyan, you are carrying behind your back the Kenyan law, and you're bound by the Kenyan law everywhere. So if you are in Dubai, you are bound by the Kenyan law in Dubai. So that if you commit a crime in Dubai, and that specific crime you've committed in Dubai is also a crime in Kenya, then Kenya will come for you and they will prosecute you. By virtue of being a Kenyan, committing a crime outside Kenya, then Kenya will come for you because you're a citizen. You're bound by the Kenyan law. And there is no geographical jurisdiction when it comes to criminal law. When you commit a crime, they will come for you. That is the first one. The second one is now the actual jurisdiction where you commit the crime. When you commit a crime in Dubai, the fact that you committed it in Dubai gives the Dubai administration the authority to come for you. And I'll give you a case. Kelvin, what is the name of this guy? This guy.
The one who is supposed to be prosecuted.
The one supposed to be extradited back to the US.
The one is supposed to be, or the one is supposed to be hanged in.
No. Leave alone that one. Leave alone that one.
It's called Kelvin Kang'ethe.
Is it Kang'ethe?
Kelvin Kang'ethe.
The one who killed a lady in the US airport.
That one. Kang'ethe. That name is funny. I don't know why people name each other that. If you're in this class and you're planning to have a kid, please, at least don't say Kang'ethe. How do you say now your daughter or your son is called Kang'ethe? Use another name, please. So that guy, I don't think, yes, I think it's called Kang'ethe. So he killed in the US. Okay, this guy killed. Actually, he killed a Kenyan in the US. Was he a Kenyan American citizen in the US? So by virtue of him being a Kenyan but killing in the US has jurisdiction to come and look for it. So remember that criminal jurisdiction is normally defined within the state will have jurisdiction within its borders all the time, and even outside the borders. Are you together? Even and that is the principle you need to understand. When you commit a crime inside a country, that country has all the jurisdiction to prosecute you because you are within their country. Okay, you are within their country, so they have all the jurisdiction, and that's why you are seeing even some heads of states, they don't want to fly into certain countries because they fear that when they get to that country, they will be arrested and be prosecuted under the international criminal law. So the moment you get into a country, you submit to their jurisdiction. But the moment you're flying into Uganda, you submit to the Ugandan law. When you come to Kenya, you submit to the Kenyan law. That is the first principle. The second principle is when you're a Kenyan forever. And therefore, whether you are in Kenya or not, the Kenyan law will still apply. So if you commit a crime outside Kenya, but that crime is a crime within the Kenyan Penal Code, we shall still come for you and punish you for that. Tuko sawa?
Now, I think maybe I didn't make myself very clear.
You're crazy.
I'm talking in a case where you are inside a vessel. Say you are still inside Kenya Airways. You landed in a foreign country, or you're in the foreign land, but you're still within the vessel that belongs to Kenya. There are some assumptions that I've heard talked about that if that vessel belongs to a particular country, then it is presumed that that crime is committed in that country which owns the vessel. For example, if you kill somebody inside a Kenya Airways in Egypt, then you have it's presumed that you killed somebody in Kenya. I don't know whether that's the right position.
Remember at all times that first, there's no vessel that is, Kenya doesn't own any plane. So we don't have any Kenya Airways registered in the name of a country though. So there's no Kenyan, but let's move away from that discussion. Now, when you kill somebody inside a plane in Dubai, and that plane belongs to belongs to Kenya. It is still simple. You have committed a crime in Dubai. Okay? You have committed a crime in Dubai. And they will come for you because they have that jurisdiction. Now, there are certain exceptions that are given when it comes to diplomacy. Okay? There's certain exemption that only applies in terms of diplomacy. Okay? That any diplomatic mission is deemed. Okay? So Kenya will have their jurisdiction within their high commissions. Okay? Within the high commissions across the world. So if there's a high commission in Dubai, then Kenya will have jurisdiction. Okay, so if you commit a crime within that specific zone, then Kenya has the actual jurisdiction by you being a Kenyan, and then still they have the geographical jurisdiction because under the rules of diplomacy, okay, the diplomatic relations, those embassies and high commissions, they are deemed to be the countries. So if you have a Kenyan high commission in the UK, that specific space is deemed to be Kenya, okay? And therefore, Kenya will have jurisdiction there. If you are in a given country and you run to a specific embassy or high commission, then specifically, that country will have jurisdiction over you, and therefore the country that you are in cannot take you away from there. And you've seen this happening a lot. So if you're in Dubai and you run to the Kenyan High Commission, then the Dubai police cannot come and just evict you out of there. They can't, because Kenya has, under the international diplomatic relations law, that specific high commission has been gazetted and has been recognized as part of Kenya. And therefore, they cannot just come in. So they have the actual jurisdiction and the long-arm jurisdiction. Are you together? But that must be specifically recognized. Okay? Airports are not recognized. Airports are not recognized to be or are not covered under the rules of international diplomatic relations and everything. They're not recognized. So you commit a crime at the Kenya Airways, the Kenyan police will come for you without playing. They will come for you. Okay? So that is the thing. So once you are within a country, there are specific zones that are exempted. Okay? Like even in Kenya, there are specific pieces of land in Kenya that are deemed to belong to the other foreign countries. So Kenya can give or can extend diplomatic protection over those, pieces of land. Okay, so that if you are there, you are deemed to be in another country. Okay, you are deemed to be in another country. So if you commit a crime in Kenya and you run to let's say the Zambian High Commission, the moment you get inside the commission, then you are deemed to be out of Kenya. Okay, you are deemed to be out of Kenya, and therefore it will take a diplomatic relations and negotiations to have you removed from the High Commission to the police station in Kenya. So those must be gazetted and must be recognized. Okay, it is an exchange. So it is under the international law. Embassies and high commissions are deemed to be countries, or they're deemed to have the territorial jurisdiction of countries owning such. But when it comes to other things other than that, then the normal principles of law apply. Tuko sawa? So airports, you're in a vehicle, you are in a ship is kind of different because a ship must be flying a flag. So if that ship is flying the Kenyan flag, then of course that is a Kenyan ship. Or, for instance, if you because remember, when it comes to criminal prosecutions, there are a lot of things that come into play. Okay, there are a lot of things that come into play. The fact that that ship is not Kenyan, but you attack or you hijack Kenyan property, then that gives Kenya jurisdiction. Okay, the fact that that ship belonged to Liberia, but it was carrying Kenyan people, then the moment you attack the Kenyan or you hijack, then Kenya will have jurisdiction. So there are a lot of factors that come into play. It's a whole thing. Tuko sawa? Hey.
Yes, mwalimu.
The person that was asking the question, where is he? Okay, so I want us to proceed, and we are going to charges. I want us to run quickly, very fast to charges. Okay. Now, before we get to charges, again, as we always say, in criminal, it is a procedure. Okay. The fact that it is a procedure means that you need, okay, you need to understand the procedure. Are you together? You need to understand the procedure. Now, criminal procedure, it will start from somewhere, it will end somewhere. Okay? It will start from somewhere, it will end somewhere. So please, let us go through the procedure again. So I want somebody to put up their hand and tell us, what is the criminal procedure? Where do we start from and where do we end? And the reason why I'm saying that is because at all times, you need to understand. If a question is set, ask yourself, which part, okay, which part of the procedure this question is coming from? So that if it is already a question past sentence, then you know how to deal with it. Somebody put up your hand, tell me. What is the procedure? Where do we start from and where do we end? Quickly, guys, time is not on our side. I want us to discuss everything about charges today. So, time. Yes, John, let's start with you.
Okay, good evening, everyone. So I would say that the criminal procedure starts where a person is arrested or where a report is made at a police station.
Where? What are you saying? Can you start from the first point? Tell us what is the first point so that we move in order. Start afresh.
Okay, I would say that it starts when a person is arrested or a report is made at the police station. And then now a charge sheet will be drafted.
Wewe utaniambia penye huko saa hii tu nitumane. Nimekuambia niko na team.
Let Michael help me then.
A team of serious and very. So if you want me to send them, Wamboi, say something.
I would say the criminal procedure begins with a complaint being made at the police station.
Thank you very much. Yes, so just before you proceed, let me just cement that. So complaint, there must be a complaint. So the first point is a complaint. Somebody must have complained. Now this complaint can be recorded or it can be instant. Okay? Instant means you're committing a crime and the police are seeing you, they arrest you there and there. Okay? So there must be a complaint. So complaint. So once there's a complaint, proceed now. So the first point is a complaint.
Then an investigation is done.
All right.
If the accused person is arrested, a decision to charge will be made. Then they'll be arraigned in court.
Well, so there is a complaint, okay? And then there is investigation. What goes into investigation? Give us the three things that you'll consider during investigation, the three main things that goes into investigation quickly, okay?
Investigation, I would say witness statements.
Where?
Then I need help on that.
Guys. You guys are crazy. Tanina, quickly. So complaint, after complaint, investigation. What goes into investigation? Just give me the 3 pointers quickly, guys. We need to move. Tanina?
I'd say preparation of files. Preparation of the police file, an identification parade, and arrests.
All right. So under investigation, normally is the question of ID parade, the question of if the person is not arrested, the question of arrest if it is needed, and of course the preparation of the files. And then after that, quickly.
You're still with me, Walimu? I've said the 3.
You're not here.
Or are you
Yes,
saying
Bishar next.
Yeah, from there is an arraignment. The suspect is arraigned to the court.
Wewe. Najua kwako wewe. I know where you stay. Don't try me. Larian Ombaso.
The file is forwarded to the DPP to make a decision to charge.
Decision to
Then-
charge. So the DPP
The
must make a
suspect-
decision to charge. And then?
Then the suspect is arraigned in court.
Yes, the suspect is arraigned in court.
Then the suspect is either charged or released, or to be informed of the reason of not being charged or released. So if the suspect is being charged, they'll have to plea. So they can take a plea of guilty or not guilty, and the others. And after that,
Don't join them. Just make them point and move. So arraignment. After arraignment, what?
the trial, bail.
Where?
Then after bail.
After arraignment is bail. After arraignment is bail.
They plea first.
So after arraignment, what comes after arraignment?
They're charged.
Then
after that, bail follows, then trial.
Take a seat, my friend. Guys, can you just give me something that is organized? What do you mean after charge this bail? And if only put up your hand if you're sure. If all of you are not sure, then I can explain and then we move forward. Rachel.
So after the charges are read, there is plea taking. And here the accused person can plead guilty or not guilty or the other pleas. And then after this is when there is bail. And then after bail, we go to pre-trial. And then after the pre-trial, we go to the trial.
Okay.
And then after the trial, we have the judgment. And then after the judgment is when we have the sentencing. Once a conviction has been reached of either guilty or they're being acquitted. If they're being acquitted, we won't go to sentencing. If they're found guilty, we move to sentencing.
All right. Thank you very much. So that is it, guys. So don't confuse it, guys. Guys. I get very mad when I hear you confusing those points. Don't. Okay? Don't confuse them. Make sure they're in order. So you start from a complaint, investigation. Okay? And investigation is wide. Okay? The police, when the police is doing the investigation, there are a lot of things they do. Okay? They can arrest you. They can conduct ID parade, and also includes the preparation of file. So once the investigation is over, then that entire file, which is the police file, is now transitioned to become the prosecution file. Okay, it is taken to the prosecutor, and the prosecutor is supposed to identify or determine whether there is sufficient ground, whether there's sufficient ground to sustain a charge. Are you together? So they will look at the evidence. That is the evidentiary threshold. Hey, Jesus Christ, Leo, let me go by. Please, those who are praying bad for me, forgive me. I'm sorry. Okay. So again, like I've said, when the file is taken to the DPP, and remember I said in the last class that you need to consider reading the DPP decision to charge guidelines, which is on their website. So they have to do an evidentiary analysis first to consider whether there is enough evidence to sustain a charge. Okay, if it's a question of murder, is there a dead body and is there a person to be charged? So if the DPP is sure that there's enough evidence, okay, to sustain a charge, then they will proceed and have the person arraigned before the court. Okay, they proceed and have the person arraigned before the court. Once the person has been arraigned before the court under Article 49(1)(f) and G, then they're supposed to be charged. Okay, they're supposed to be charged. If they're not being charged, that is an entire different topic that we had in the last class. They're supposed to be charged. Okay, now after they are being charged, then they need to take a plea. So from charges, there's a plea because you plead to the charge. Okay, now before they take a plea, normally the law requires that the court is supposed to ascertain few things. Number one is whether this person is of sound mind. So the mental soundness of this person must be checked. Okay, but of course in practice the court only makes it a requirement if the offense is capital offense, murder. But the law provides that every accused person, you need to assess their mental health before you proceed with the charges. Number two is a question of representation. Do you need an advocate? Is it a crime that would require you to have an advocate? And in this case, specifically, we talked about the case of, what is the case that we talked about? Karisa Chengo, which was a Supreme Court case where the court now identified and discussed and outlined some of the factors the court will consider before an accused person is given an advocate. Okay. The third one is the question of whether you understand the language of the court. Whether you understand the language of the court. Okay. So if you understand the language of the court, then we proceed. If you don't understand the language of the court, that is English in the High Court or Swahili or English in the Magistrate Court, then we shall provide you with a translator, okay, to translate. So once the court is sure that all those 3 points are checked, then the accused person will be required to take the plea, okay? So you plead whether you are guilty or not guilty, or all those pleas that are listed under Section 207 of the CPC. After you plead, then the next thing that the court must do is the question of, first we have to note your plea. Once we note your plea, then we proceed to talk about bail. So the next thing after plea is bail. Now this is where we decide whether we are going to release you on bail or not. So bail, so plea, bail. Okay. So you are arraigned, you are charged, you plead, and then bail. So after bail, then we prepare for hearing. Okay. So we go to pre-trial. Okay, now the pre-trial is where we discuss the pre-trial issues. And then after that, we go to the trial, which is Section 208 all the way to 211. So the trial process, we shall discuss that later. So we go to trial. After the trial, there's judgment. Okay, and then after judgment, there's a sentence. So understand that. Guys, it is very easy for you when you read a question and you are clearly seeing that this is a question on bail or this is a question on charges. So make sure you know that, okay? Because some of them will come with certain documents to be prepared or to be discussed. So you can only address that if you know that. So please make sure you understand that bit clearly. Make sure you understand that bit. That is the general process. And I don't want to take questions on that. There's no question I'm taking on that. That is just the stages I've listed. Now, let us go back to charges. So in terms of charges, the accused person has been arraigned before the court. And the law says you have to charge them. What is a charge? A charge is a complaint. Okay? A charge is a complaint. A charge is an allegation against the accused person. Okay? So you have to tell the accused person that they are being accused of doing this thing and this thing. That is a charge. They're being charged. So you read out the charges to them. Okay? So before we get there, we need to understand what charges really are. So we have said charges are the complaints. Are you together? So in terms of charges, the entire topic of charges, we'll discuss the question of framing of charges. But first, we discuss the powers of the DPP. I gave this assignment. I said, guys, in the previous classes, okay, that read the powers of the DPP. It is very important for you to read the powers of the DPP. That is under Article 157. Once you understand the powers of the DPP, then it is easy for you. Even those of you that would want to to become prosecutors in the future, please read the powers of the DPP. It is helpful for you to understand because it is the DPP that will have the power, number one, to initiate a charge, okay? Number two, to prosecute. And then number three, to terminate any charge. That is the DPP. So that is given to the DPP as the nolle prosequi under 82 of the CPC. And also the officers under the DPP can also withdraw a matter under section 87 of the CPC. So generally, it gives the DPP the power to bring a charge and to withdraw or terminate those charges. So that is the powers of the DPP. Article 157, I don't want to go deep into it because it's not subject to our discussion, but make sure you understand that. I want you to understand that bit very properly. Okay? The next thing is framing of charges. We discuss framing of charges. And then we will look at how do you draft that? Okay, how do you draft that? How do you frame charges even in an exam or even in practice? And then the next thing is the question of joinder of parties. How do you join parties in a charge sheet? How do you join persons in a charge sheet? Okay. Well, saying S and H all at the same time is a serious thing. We need to be recognized by the government. We need to be recognized by the government for the hard work. You know, when those two letters follow each other, there's trouble. So, well, I'm even sweating from just saying S and H. So, anyway, that is that. So let us get into it. I'm trying to upload my, bring up a charge sheet so that we can look at the charge sheet, draw a charge sheet, and then get done, and then see how it's done. So guys, there's going to be a question on a charge. Whether you die today, when you wake up, whichever place you'll be, either in hell or in heaven, those who shall have sat this paper and will be with you in hell or in heaven, they will tell you that actually charge was there. It will never miss. Okay? Whether you go and sit this exam in heaven, you will still find a charge sheet there. So it is one thing that you can't avoid. Okay, you can't avoid it. So let me just let's say, let me bring it up real quick. Right there. So we have two things. We have a charge sheet and an information. Okay, we have a charge sheet and an information. Okay, again, let me bring that up as well. Let me bring that up as well. So we have a charge sheet and an information. Okay, now, anytime a person has been arrested and they're being arraigned before the magistrate court, they have to be brought by a charge sheet. It is called a charge sheet in the lower court. However, when you are before the high court, it is called an information. Okay. Now, there is no reason at all why one is called an information and one is called a charge sheet. Okay. It all narrows down to the pre-colonial times when the judges used to sit in the high court and they were whites. Okay. The white judges used to sit in the high court. And then the magistrates who were Africans used to sit in the lower court. Okay, and that is how we came even with things like revision and everything else. It was just colonial things. Okay, even murder being tried at the high court was just a colonial thing that has really stuck with us for a long time. Okay, so what we know currently is that you can't go to the high court without an information. The same way you can't go to a magistrate court without a charge sheet. Okay, so that is that. So I'm trying to project. I'm trying to project an information. You guys have seen a charge sheet, so let me project an information so that I'm giving you this for Mobado is Zachariah Okop Mobado. I don't know whether you can see that. Is it visible?
Yes, it is.
So normally, it looks like this. Okay, it looks like this. This is how it looks like. Okay. Now, when you're going to the High Court, this is how you go to the High Court. There is an information. Republic of Kenya in the High Court of Kenya, that place, criminal case number that, this Republic versus the accused person, the information. Okay. And then you have to write that the court is hereby informed by the DPP on behalf of the Republic that the above named accused person is charged with the following offenses. You don't need to write that. In an exam, you don't need to write that specific information. Just write information and then go to the statement of offense, and then particulars of offense, and then the date, and then the signature. That is how simple an information is. When you go to a charge sheet, in practice, a charge sheet is very complicated, very, very complicated. Okay, it's extremely complicated. Okay, that is what I'm saying. It is extremely complicated. So what is the complication? You have to draw tables and everything else and everything else. It is not important. All those information that you're going to get, you're going to provide in a charge sheet in practice is not important. Now, when you are in an exam, what do you draft? You draft this, what you're seeing on your screen. Anytime you're told to draft a charge sheet or an information, you draft this that you're seeing on your screen. Okay, so don't go drawing tables in an exam. Just write it as simple as possible. We're going to see one so that you see that. So this is an information in practice, in real life. This is what an information looks like. And this is exactly what you're going to draft in an exam should you be told to prepare a charge sheet or an information. So if you're told to prepare a charge sheet in an exam, this is what you're going to draft. Okay, but of course without the High Court, aspect. Just the Republic of Kenya, Republic versus XYZ, charge sheet, underline, statement of offense, particulars, and all that. So make it as simple as possible. Okay, make it as simple as possible. So this is what you will be drafting. This is what you'll be drafting. All right, so let's go and look at now how to prepare charges. Let us go and look at how to prepare charges, because that is very important for our discussion today. So projecting my screen there. I'm projecting my screen there. So don't get confused. And again, I said, when you're in KSL, don't avoid templates or templates that can confuse you. Okay. Confusion. Can you see my screen? Okay. All right. So it's as simple as it can. It can be. Okay. Just give me a minute. Let me add that one there. It's as simple as it can be. Okay. Let me just take it back. All right, there it is. So this is what we are calling a charge sheet. Okay, this is what you are calling a charge sheet. It is a simple. In an exam, this is what you draft. Don't start telling us you're drafting those columns and rows, the name of the accused person, their middle name, their last name, their age, their gender, their village, their county, the name of their grandmother. We don't care about those information. Just tell us the name of this person, identify the person, and go straight into the substance of the charge. Are we together? So don't waste time drafting. That charge sheet is a standard document. Whatever you are seeing, it is a standard document. So you'll draft it in fact, you'll not even draft it. You just fill it in practice. But when it comes to an exam, simple, like we always say, keep your documents simple and direct. Okay. Now, let us talk about what goes into a charge sheet. Okay. Let us talk about what goes into a charge sheet. What is it that goes into a charge sheet? The ingredients of a charge sheet are two. Okay. The statement of offense and the particulars of the offense. Okay. Now, what is a statement of offense? The statement of offense is the specific section, okay, or the specific offense that the accused person has committed. So you have to provide the specific offense the accused person is being accused of and the specific section that offense is provided for. Now, this takes us back to the principles of criminal law, the nulla crimens, okay? The first one was that there is no crime without the law. And that therefore means you cannot say stealing. You cannot just say stealing. So you have to tell us stealing contrary to section 268 of the Penal Code. So you have to tell us the section that defines who said that is a crime. That is exactly what that section is saying. Who said it is a crime? Are you together? That is the question that we are seeking to answer here. Who said it is a crime? And how do we address that? We address that by indicating the section of the of the law that has been violated. So that is what you need to understand. That is what you need to understand. Perfect. Now, when you are preparing your statement of offense, two things must be there. The first one is the offense itself as defined under the law that provides for that offense. Number two is the section that that offense is provided for. Number two, remember that if that offense is defined in one section and the punishment is defined under another section, then you have to read those two sections together. Okay? Like we said, the two principles of legality. Number one is no crime without the law. One, no punishment without the law. Okay? So when it's an offense of stealing, there are two things. The stealing, fine, that is an offense. So what? Then the so what becomes the punishment for stealing. Okay? So if you are saying that stealing is an offense, then what is the punishment for stealing? Okay? And for that reason, you have to give us, number one, your statement of offense must give us the section defining the offense and the section defining the punishment. Okay? So that when I read your statement of offense, I can be able to see that this offense is defined here and punishment, provided here. Now, in most instances, that will be done under one section. For instance, under stealing, okay? You will find that it is defined in one section and the same section will be providing the punishment, okay? For instance, if you're talking about rape, for instance, then you'll be saying rape is defined under section 3 of the Sexual Offences Act, and the same section provides the punishment for rape. Are you together? If it is assault under section 252, it is the same section that defines it and the same section that provides for the punishment. Okay, so you don't need to have two sections there. So you'll simply be saying assault contrary to section 252 of the Penal Code. Okay. In other instances, there are two different sections. For instance, murder. Okay. Now, murder is defined under section 200 and 203. Okay. And then the punishment for murder is placed under section 204. So you have to read the two together. So what will you be saying? Murder, like you can see on my screen, Let me just write murder. Murder, contrary to what sections of the law? Section 203, as read together with section 204 of the Penal Code. So you read them together. Why? Because remember the principle of legality. There is no punishment without law, and there is no crime without law. So if you charge this person with the offense of murder under section 203 without mentioning section 204, then it means at the tail end of this process, after judgment, okay, after judgment, that is where it will end. You will not sentence this person to anything. Why? Because the charge sheet did not mention the section for the punishment. So for you to go into sentences, that sentence must be within the law. Remember, you can only punish me for something that is provided for in the law. Okay? You cannot just decide that I'm going to sentence you to 10 years in prison. That 10 years in prison must be defined in the law. Now, if it is defined in the law, then when you're providing the statement of offense, you must include that also. So if that is in the different section, you read them together. Like murder, like robbery with violence. So if it is robbery with violence, you know it is section 296 of the Penal Code as read together, 295 and 296 too. Okay, you read them together. Are together? So that is what you're saying. That is what we are saying. That is what you're saying. So you read them together. But how will you know that? Again, it is easy for you. It is easy for you because in an exam, you will have your penal code. Okay? You will have the penal code in an exam. So what do you do with the penal code? Just go to the penal code, go to murder, read the section that defines it, and then check, is this section also providing the punishment? What is the punishment for murder? If it is not provided in that section, it is provided for in the next section. So go to the next section. And then when you find that, you put them together and then say as read together with. The problem with that is some of you, you know, those people that you can be told that bring all your notes, all your books, okay? All your notes and all your books in this exam. And some of you will still not find where that thing is. So you can have the penal code, yes, but you'll peruse that penal code in the whole time without finding anything. So again, start making friends with the penal code. Okay? Some of you have never seen the penal code. I'm not even exaggerating. I'm not even trying to exaggerate. Some of you have never seen the penal code. Some of you they know there's a penal code. They hear it. They quote it. They talk about it. Okay? It is sweet in their mouth, but very, very sour in their eyes. Okay? So they just talk about it, but they don't read it. I'm not telling you to go read it. I'm just telling you, just take it, check it out, peruse it a little bit, check a few offenses. Okay? So that when you're given that penal code, there's a reason why the examiner gives you that. Because most of you don't even know it. So get the penal code, hard copy, soft copy, anything. In some of the previous exams, if you look at even the CLE website, where somebody was, the question was asking you to charge someone with an offense, and somebody saying that that offense is from the Rape Act, you know, that an offense is from the Rape Act. And that is how you know that people don't check these things out. There's no Rape Act. We don't have any Rape Act. The sexual offenses were in the Penal Code until the Penal Code was amended, and then now they are in the Sexual Offences Act. Now, while at it, remember that the Sexual Offences Act also is in the process of being amended. Okay, they're amending the sexual offenses. Okay, you already know that the Chief Justice is our good lady, the incoming Attorney General, the same. The President of the Law Society of Kenya, the same. So if you're planning to commit a sexual offense, my friend, if your client has committed a sexual offense, start making contacts at committee, you know, start making contacts at committee because that is where you're going, okay? So it's not even a joke. The Sexual Offences Act is being amended, okay? It's being amended. So they're trying to, I'll share a few things in terms of what the proposals, what they're proposing, but also find that out. So it's going to be tough and tougher, okay? Tougher and tougher. So please, please, please advise your people to turn to Jesus Christ, turn to Christ, flee away, okay? You know, it's, I told you that my long-time goal, my long-term dream was to become a pastor, you know? And when you read the Bible says that, you know, for all offenses in the Bible, there's only one sin that the Bible says you should run away from, flee, okay? Flee from sexual offenses. Even the Bible knows that, okay? The Bible says don't kill, don't steal, don't beat, but when it gets to the point of sexual offense, you need to flee away, okay? So that is why. So when the law catches up with you, my friend, it will be tough. So don't do that. Be a good Christian and be a good Muslim and a good citizen. So that is that. So we have the Penal Code and the Sexual Offences Act. So the Sexual Offences Act provides for the sexual offences. I've given it assignment in terms of look at some of the proposals that are coming from the key interested parties, like FIDA and the state law departments in terms of what needs to be changed. Okay, there are current discussions within the LSK again to see how they're going to amend a few things and have a proper working act. Okay, so that is that. So let us get into the second one. So we're done. Any person having a question in the first one? Not now though. Let's go to the second one. So the first one is a statement of offense. So under section 134 of the CPC, it talks about the ingredients of a charge sheet. Okay, ingredients of a charge. Okay, before I even get there, I forgot to mention there are two different things. There's a charge sheet and there's a charge. Okay, guys, there's a charge sheet and there's a charge. What you can see on your screen, the document that I'm projecting, is a charge sheet. Okay, but what I've highlighted in blue is a charge. If you are told to prepare a charge, this is what you're going to prepare. This is what you're seeing in blue. A charge sheet is a document that carries the charge. Okay, so you can simply prepare the charge without having to prepare the charge sheet. So what makes a charge a charge? Number one, it is the statement of offense, which highlights the offense, the punishment, and the section it was coined. And then secondly is the particulars of the offense. The particulars of the offense. Altogether, now the particulars of the offense. So a charge sheet is complete, or a charge is complete if it has both the statement and the particulars. So how do you write the particulars? How do you write the particulars? Okay, now the particulars of the offense is supposed to answer one simple question. The particulars is supposed to answer one simple question. What is the simple question? Who did what, where, and when? I hope you understood that. Who did what, where, and when. So when you are preparing your statement, your particulars of offense, I should be able to read it, okay, and see who, what they did, when they did it, and where they did it. That is all. So who did what, where, and when? That is exactly what you need to have when it comes to preparation of the particulars of the offense. So don't give me too much information. Guys, we have particulars of offense, and then we have the facts. Now, the facts of the case is different from particulars. So the facts will be, on this day, you are walking in Rongai, you are having a red jacket, you are singing, you are having your jacket on, you are talking to somebody, you are carrying a knife, you went to this house, you sat down, so that is the fact. That is the fact. Now, from the fact, we are supposed to get now a summarized version, which now makes the particulars of the offense, which is who did what, where, and when. How they did it is not part of the particulars. How they did it is part of the facts. Okay? So, in our case, okay, so this was stealing. This was stealing. So let's take it back to stealing. So in our case, the offense here is stealing. Okay, and it is stealing contrary to section 268 of the Penal Code. Stealing contrary to section 268 of the Penal Code. Are you together? Now, what are the particulars? Who did what, where, and when? That is what should be at the back of your mind. So, who? Michael. On the 21st, you have to tell the person, you have to name the person there. If there are many, you'll number them. 1, Michael. 2, Peter. 3, Stephen. On this day, at this time, at this place, you did this. Okay, so in our case, it's just one person, Michael. On the 21st day of December 2021, that was already given as the question of when. At Rongai Estate, where you stole an HP laptop belonging to Susan. What they did. So, who? Michael. What did they do? They stole an HP laptop belonging to who? Belonging to Susan. Where? Rongai. When? 21st of December 2021. Now, don't gaze this information. If you're not told the place, don't force it. You know, some people like forcing issues. When they are professional, issue forcers. Kitu lazima tu ingiane, hata kama ingiani, lazima ingiane tu. So you're like, nilisoma hii kitu lazima ibaki kwa exam. Siwezi rudi nyumbani nayo. So yes, don't force it. If it is not there, if you're not told it was Rongai or Nairobi, don't force it and say it is Rongai, that I know this offense can only be committed in Rongai. No, don't do that. Okay? Remember, you're guided by the facts the examiner will give you. So if you're told, if you're told the date, just write Michael on the 21st day of December, you stole, but that will be insufficient. So even the examiner will try and give you more information. But if you're not given the more information, please don't go out looking for more information. But Michael, on the 21st day of this day, at this place, you did this, X, Y, and Z. Tukonzawa? That is what we are talking about. So if it is offense of stealing, guys, you must also see the actus reus of that offense. So you stole an HP laptop. So why do we need to say belonging to Susan? Because remember, when you are stealing, the act of stealing is you take something that is not yours. So that must also be established. Okay? Are we together? So assuming it was manslaughter. Somebody put up your hand. Tell me, if this offense was manslaughter, how would you frame your charge? Mikono ziende juu. Mikono ziende juu. Ala, mimi ni kwa nchi ingine. Mimi naona niko kwa nchi ingine. Omwenga, please help me. Manslaughter.
I just want to make a trial.
Statement of offense.
I
What will you
start
have
from
under?
us. Yeah.
Yes. Start from the statement of offense.
Okay. Manslaughter contrary to section 205 of the Penal Code.
Wewe. Nikutafute. Manslaughter is under what section of the law, guys? Wamboi, Kiarie, please talk to me.
I can attempt making the statement of offense. I would say a manslaughter, contrary to section 202, as read together with section 205 of the Penal Code.
What is 205 saying? What is
205
202 saying? What is 202 saying?
202 says any person who by an unlawful act or omission causes the death of another person is guilty of the felony termed manslaughter. Then 205 is punishment for manslaughter. Any person who commits the felony of manslaughter is liable to imprisonment for life.
Yes. Perfect. So, what are we saying? Number one, manslaughter, contrary to section 202, as read together with 205 of the Penal Code. So, Omwenga Mora, you don't start with the punishment. You first start with the section, okay, and then you go to the particulars. Now proceed. So our person is Michael still. Bishar.
And I can attempt.
Let's Bishar try.
Michael, on 21st day of December 2021 at Rongai Estate, killed.
Come again. Michael, on the 21st?
Day of December 2021 at Rongai Estate, killed or conspired to kill.
Wewe. Hizi vitu sidhani kama unaonja. Wewe pia unaonja. What do you mean conspire to kill? That is conspiracy. That is a different offense. How do you say conspire to kill?
No, I just withdraw that conspire, but killed as Susan.
You killed. You have to tell. You are addressing the person directly. So you're telling him, Michael, on this day, at this day, at this time, at this place, you killed.
You killed. Yeah, you killed Susan.
Yes. So remember that killing. So for manslaughter, it is killing. For murder, you murdered. Okay? You murdered. Even when you look at the definition, you look at the definition of those offenses under the Penal Code. For murder is just murder. Any person that commits murder. And then for manslaughter, it is killing. So manslaughter is killing because there's no mens rea. And then for murder is murdered. Stealing, you stole. Again, don't try looking for other words don't invent. Just call it the way it is. You assaulted. Okay? If it is about something to do with robbery, okay? You know how robbery is defined. If you know robbery with violence, you know what are the elements of robbery with violence. The fact, number one, this aspect of violence or threatening to use violence, and number two is the question to do with a weapon. Number three is being in the company of more than one person. Okay, so if you are more than one person, then that of course becomes robbery with violence. Are you together? It becomes robbery with violence. Now, in that instance, then you need to understand that if somebody has been accused of robbery with violence, then one of those aspects must be there in your actual particulars of the offense. So Michael, okay. So if Michael was armed with a weapon, so you say, on this day, at this time, at this place, while being armed with a dangerous weapon or with a weapon, namely, you have to name the weapon that he was armed with, a gun or a machete, okay? You robbed. Who do they rob? This, or start with what they robbed. They robbed a laptop belonging to Susan. If there are more than one person, then you'll be saying Michael, 1, Peter, 2, okay? On this day, at this time, at this place, okay? While in the company of each other. Or if there are others not before the court, you'll be saying, while in the company of others not before the court, and while armed with a weapon, or, you know, if they're, like I've said, the points are 3, armed, force, and then more than one person. So if there are more than one person while in the company of each other or company of others not before the court, you robbed an HP laptop belonging to Susan, full stop. If it was if they were armed, and then you say, while in the company of each other and armed, okay, with a weapon, and you have to indicate that weapon, which is a gun, a knife, anything that they were carrying, you robbed an HP laptop belonging to Susan, okay? If they used force, if there are 2 and they used force, 1, Michael, 2, Peter, while in the company of each other, and while using force, you robbed, okay? So that is how you talk. So don't try and twist, just call the offense, okay? Call the offense. Are you together? So let's assume the offense is rape, for instance. So I want someone to put up their hand. Weka mikono juu. Nobody's having their hand up. Tell me, rape. That's a sexual offense. Guys, Amko. Guys, we need to move very fast. Banafa Abdul Kadir. Okay.
Section 3 of the Sexual Offences Act. Number 2.
So rape, contrary to section 3 of the Sexual Offences Act. Michael, on the 21st day of December at Rongai Estate, what did you do? Banafa Abdul Kadir.
You intentionally caused penetration to, for example, Susan.
What do you mean intentionally caused penetration? Are you shy from calling the word? So when it comes to sexual offenses, in an exam, you have to call it. Okay? You have to balance and weigh. Do I want to go to heaven or do I want to pass? Okay, so you have to weigh and see which one is heavier than the other. Okay, so you have to call it, call the spade. For other offenses in the penal code, you just say you robbed, you killed, you murdered, you assaulted, you stole. When it comes to Sexual Offences Act, you have to specifically say exactly what happened. So, Michael, on the 21st day of December 2021 at Rongai Estate, okay, without consent, because remember, you know what rape is. Without consent, you caused. You caused. You are that one of time. I'm very serious with going to heaven. Nothing in this world can stop me from going to heaven, not even exams. So you caused your male genitalia. You have to mention it. You know what I'm talking about. Just laugh behind the screen there. So you have to mention it. You caused your male genitalia to penetrate. Okay, male genitalia, namely that one, to penetrate the female genitalia of person XYZ. Okay, so what must be clear there, guys? What must be clear there? Number one, without consent. Number two, the penetration. Okay, so you, without consent, you caused your male, okay, the male genitalia to penetrate the female genitalia of this person. So you have to call it whatever it is. Are we together? For me, I will not. Heaven is the goal. Sawa sawa. So that is the sexual offenses. So when it comes to defilement again, what is important under defilement? You know, defilement is about the age. Okay. The age. Consent is not in defilement. There's no consent in defilement. So if it is defilement, again under section 4, section 4, Michael, on this date at this time, you caused your male genitalia to penetrate the female genitalia of this person. Okay, so that must be very clear. So that is the question to do with preparation of the charges. Now, if you just have one charge and you're preparing a charge sheet, then this charge sheet will end there. And then you come and date. Okay, you date and then you sign. The person signing is the officer in charge. So it could be the prosecutor, the DP, anybody will sign. The question will tell you who will sign. So that is how you prepare charges, and that is how you prepare the charge sheet. Okay, so without the signing bit, you just have a charge. So if signing is included, you have a charge sheet, because now you are signing a paper. So the paper is the sheet. Okay, the charge is the substance, which is the statement of offense and the particulars of the offense. Are we together? So that is, guys, is that clear? Tell me it is clear so that I can proceed to the next question or to the next point, which is the question to do with joinders.
It's clear, Mwalimu.
It's clear.
All right, let me bring up
Mwalimu,
my
I have
seat.
Mwalimu.
Yes.
Though I have raised my hand. And what about if with offenses, are you supposed to go maybe the subsections that Section 3 of the Sexual Offense Act, subsection 1 stated the offense, and subsection 3 the punishment? Can you say, what about if you say contrary to 3 1 as read with 3.3?
That is still clear. That is still okay. But instead of going through that hassle, all of them are just section 3. So just put them together and say section 3. Okay. But if you know, okay, And if you know it is this and you're sure, I mean, yes, you can say 2-1 as contrary to section 2-1 as read together with section 2-2. But again, all of them are 2. So just say 2. But you can't do that. You are still correct. Okay? All right. Tua John, your next question quickly.
So on that point of defilement, you've said that the most important thing there to bring out is the age of the victim. So you indicate the age as you outline the particulars.
Yes.
Okay.
You indicate the age. Sometimes they will not indicate the age. Sometimes they don't indicate the age. But remember that what makes it defilement is the age. So in fact, as you prosecute that matter, you as the prosecutor, what you'll be trying to prove is that there was penetration. This person was underage, and then the person that committed it is this person. Okay, so those are the things that you're going to. So age is very important. Age is not just in terms of preparation of the charges, but also when it comes to the questions of now prosecuting the matter. Okay, prosecuting the matter. Are you together? So that is very important. So that is a fact. So because without the age, there is no defilement. Without the age, there's no defilement. So there's no consent. There is no consent when it comes to because a child cannot consent. Any person that is below the age of 18, any person that is below the age of 18 is not able to give consent to anything. And maybe the penal code should, I mean, the Sexual Offences Act should be, they need to take up the age of consent, maybe to 30. Okay, 30, so that people can stay disciplined. Okay, so before you hit the age of 30, the only thing ni Biblia tu na Quran, mpaka ugonge 30 kwanza. Japo wengine wanaumizwa moyoni, lakini ni sawa. So as it stands right now, it is the age is 18. In other jurisdictions, there are two things. There is the age of consent and then the child's age. So in Kenya, a child is anyone below the age of 18. At the same time, the age of consent is 18. In other jurisdictions, the age of consent is as low as 14 years. A child is anyone below the age of 18, but the age of consent is also lower. So a child can give consent in other jurisdictions, not in Kenya. Okay, so if you are in Kenya, so before you try to commit an offense, you need to slap yourself and ask yourself, bado niko Kenya au nimetoka? So kama bado uko, you can see yourself, you're still in the same house. Don't run away. So that is that. So I want us to go and talk about joinder of parties. Joinder, it is very important that you understand the question of joinders. Joinder, very, very important. Okay. Alingo Penina.
Yes, Mwalimu. I have a question. With the particulars of offense, the one that you said, for example, Michael on 21st day of December 2021. Mwalimu, when you mention the place and the date of the occurrence of the offense, the date, the venue, what is the impact of not including that part of unlawful? Does it have a major impact when you?
What do you mean unlawful?
Like in the statement in the particulars of offense, when you say, for example, Michael on 21st day of December 2021 at Rongai Estate, you stole. Before that word you stole, can you include you unlawfully stole? Or does it doesn't have an impact on that because the act itself is unlawful? It is against the law.
But when you say you are lawfully stole, it means there's lawful stealing. Is there lawful stealing?
No, there's no lawful stealing, Mwalimu.
Yeah, so when you say you unlawfully stole, it means the opposite is true, that there's some lawful stealing. So is there lawful stealing? No. So stealing is an offense. Stealing is unlawful. Okay, stealing is unlawful itself. So you cannot say you unlawfully stole. It means then you're predicting that there could be a lawful stealing. Okay.
Okay. Yes.
Yes.
Thank you.
And also remember, you want to avoid many words in the particulars. All those will form part of the facts. But when it comes to particulars, you have to be straight to the point. You have to be straight to the point. Okay, so that is what I'm saying. All right. Somebody called Flavia. Flavia, are you here? Flavia.
Yeah, I'm here. Good evening, Mwalimu. I'm really sorry. My network has been, and so I keep.
Yes, I was wondering. What's happening with you. I've been adding you since I started this class. I hope you've sorted it out now.
I'm hoping. Thank you.
All right, that's fine. But I hope have you understood everything we have said so far?
Yes, I've been following.
Okay, perfect. All right, Sawa. So that is that. So I want us to go to joinder of persons and joinder of counts. John, I'm moving very fast. So if you have a question, ask.
Yes, just 1 minute. I was just wondering, in this charge sheet that you have just drafted, if you had an alternative charge or another account.
Don't go there fast. Don't jump before the train.
Yes.
So guys, what I've projected there is just the basic charge. Okay, is the basic charge. That is what I was projecting, the basic one. Okay, the basic one. What I mean by basic is when there's one offense committed by one person. Okay, now we are going now to an instance where there's two offenses, there are more people, and they're alternatives. So we are going to get there, and we're going to be building that charge sheet as we go. Tuko sawa, Joan?
Yes, that is perfect. Thank you.
Okay. Sawa. So when 134 is the one that defines the charges and informations, of course, every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. Okay? Now, let us go to joinder of persons first. Or let's go to joinder of counts. Okay, let's start with joinder of counts. So how do you join counts? Okay, how do you join counts? So what is a count? Okay, what is a count? Now a count is another offense. Okay, a count is another offense. I want you to understand that a count is another offense. Okay, so if somebody commits two offenses, then those offenses are going to be called counts. Count 1, count 2. So we are charging you with counts. Okay, so a count is just an offense. Okay, so if there are more than one, if just one count, we don't need to say count 1. We just say statement of offense, particulars, if it's just one offense. But if this person commits more than one offense, then that becomes a count now. We start counting and we'll be saying count 1, count 2, count 3. And each and every count will have its own particulars of the offense. Are we together?
Yes, Mwalimu.
Yes, so that is a count. So we are starting with the joinder of counts. Okay, so what is a joinder of counts? Now, joinder of counts simply means we are joining two counts in the same charge sheet. Okay, we are joining two counts in the same charge sheet. Are you together? That this person committed two offenses. He committed two offenses. Okay, now remember that the fact that this person committed 2 offenses doesn't mean we should join them together or we should join the counts together. Okay, and I will read for you what 35 says. Any offenses, whether felonies or misdemeanors, may be charged together in the same charge or information if the offenses charged are founded on the same facts or form or are part of a series of offenses of the same or similar character, the same transaction. Are we together? Or should I repeat that? So, any offense, let me just highlight that for you. If the offenses, yes, let me take it there. If the offenses, okay, charged are found on the same facts or they form or are part of a series of offenses of the same or similar character. So if somebody has been accused of an offense, committing an offense, 2 offenses, when are we going to join those counts? Okay, we are going to join those counts. Number 1, if those offenses are committed in the same transaction, what we call the same transaction. What is the meaning of the same transaction? It means those offenses are committed in the same fact pattern. So while he was stealing, he assaulted, he committed rape, and then he robbed something again. So that same transaction, same place, same time, different offenses. But if he stole today and then 2 weeks later he stole again, you can't charge him on the same charge sheet. No. That is not a reason. So those offenses must have been committed on the same fact pattern, what you're calling the similar transaction. So they went to this house, they stole. After stealing, they committed a sexual offense. After committing the sexual offense, as they're leaving the gate, they assault the gate man. So those are 3 offenses that are committed in the course of the same transaction. So that is when you will join those 2 offenses or the 3 offenses together. And that is by joinder of counts. So joinder of counts simply means you are bringing counts together. You are bringing counts together, offenses together in the same charge sheet. What is the qualification? You can only bring those 2 charges together if they were committed in the same transaction. Guys, are we together?
Yes, Molly.
All right, so if we are together, let us go back and look at the charge sheet on the screen. So let's build it up and have some counts there. I hope you can see my screen. So our person here is Michael. Okay. Our man here is Michael, man of the day, man of the hour, is Michael. Okay, that is the person. Now, this person has committed 2 offenses. He has stolen something, and as he's leaving, he has also committed assault. Okay, now, how are we going to charge this person? So we are going to have counts. So how are we going to have counts? So normally, the seriousest, if there's a word like that, count 1 is usually the most serious. Okay, the most serious offense comes, so it goes down as the serious first and then the less serious later. So the first one is the most serious one. So count 1. Count 1. Okay, statement of the offense: stealing contrary to section 268 of the Penal Code. Michael, on this day, at this time, at this place, you stole an HP laptop belonging to Susan. We are done with that offense. That is count 1. And then we move to count 2. Okay, count 2. Let me just we go to count 2. Now count 2 is a different offense now, assault. So we are going to have the same thing. What am I doing? We are going to have the same thing. Let me just copy paste it and put it there. Okay, statement of offense. So each count must have its own statement in particular. So our second offense is assault. So let's say assault causing bodily harm contrary to section 234 of the Penal Code. There are two variations of assault under 234 and 251, so you need to confirm which one is which. The grievous one is 234, and then the simple assault is under 230. 252. So you will have your penal code there, so you just need to run and check so that you only type it the way it is, the name of the offense the way it is in the penal code, which you will have. Okay, so you can copy paste. Okay, just copy paste. But some of you are also poor at copy pasting. You copy paste the wrong thing. You will copy paste until you copy paste the penal code itself. Back one day hapo section. Section 231. Don't do that. You know, some people are very funny. You tell them to copy something, they copy until something they don't copy. Okay, so watch yourself. Have some self-control as you copy. Okay, watch your steps. So just copy paste what is relevant, and in this case is the title of the case. I mean the offense, which is assault causing bodily harm or the grievous assault. Okay, so that is our second offense. So count 2, again, statement of offense and particulars of the offense. Okay, so we are going to do the same thing. Michael. Wait. Michael. Control C. You assaulted. You assaulted Susan. Okay. Now that is sufficient, but the examiner can give you further details. Okay, like you cut their finger, you cut their neck, or you beat them with a club. So whatever the examiner says, that's what we do there. You assaulted by doing that. Okay, so you assaulting is enough. You assaulted Susan. Okay, that is all. If we do have another count, we shall have count 3. Okay, so far we only have 2 offenses. Now the reason why, guys, the reason why we are joining these 2 offenses together, because they're committed in the same transaction, and you can see from the particulars on the 21st day of December at Rongai. On the 21st day of December at Rongai. So you can't have on the 21st day of December at Rongai and then on the 1st of June in Garissa. Those 2 are different. So they must be under the similar set of patterns, similar facts, same transaction. While you are doing this, you did this, or after doing this, you did this, or before you did this, you did this. Are you together? Those are similar transactions. Guys, are we together on that point in terms of how to count? So if one person has been accused of doing this, then that is how you count them. Now, how do you do that? When you read a question, you are going to get a lot of people and a lot of offenses, or one person with a lot of offenses. So don't start with the people, start with the offenses. So as you read, write down, okay, that one is stealing. Okay, no, this one also, the second one is assault. Stealing, assault. Sindio? And then after that is when you go back to the question and ask yourself, now, who committed stealing? And then write under it, Michael. And then you come again and ask yourself, who committed assault? Also Michael. And then you know, count 1, stealing, count 2, assault. And then you put them down like that. But if you start with people, it is hard for you to trace. Most of there are so many people. Okay? That is what we're saying. Now, that is count 1, count 2, joinder of counts. We are done with joinder of counts. This is how you join counts. Okay, I'll minimize the screen. I don't know if I can remove this thing. Let me try and remove. Need it. Very stubborn. Ah. You can see that the whole page.
Yes, we can.
Yes, so if you're taking a screenshot, you can take that screenshot down. But I will try and share this in the group. So this is how you join. This is how you join. How you join counts. This is joint of counts. Count 1, count 2. Okay? Count 1 and count 2. And then you go to count 3. Now let us try and join people. Somebody's video is on. Kegei Anyanzo, you are the culprit. All right. So let us try and join people. We have joined counts. Now we are joining people. Joinder of persons. Joinder of persons. Now let us go back to them. Let us go back to them to our CPC and read joinder of persons. Now joinder of persons simply means there are now more people being put together in one charge sheet. The general rule, the basic simple rule is that one charge sheet, one person, one offense. Okay, one charge sheet, one person, one offense. That is the basic bare minimum. But we can have one charge sheet, one person, 3 offenses, or one charge sheet, 2 people, 1 offense or 2 offenses. Again, let us see. Okay, so let us go and talk about joinder of persons, who you can join or when you can join people. Okay, joinder of persons simply means you are joining people, more than one person in the same charge sheet. That is joinder of persons. Okay, that is joinder of persons. All right, if you can see my screen, under section 136 of the CPC, joinder of 2 or more accused persons in the same or in one charge or information. Now, the first person you are going to join together, when do you join 2 people together? For instance, if it is Michael and Peter, how are you going to determine that Michael comes first and Peter comes, or how are you going to determine that you're going to bring them together? Okay, how are you going to determine that? That is what you're calling joinder. So the first one, a person or persons accused of the same offense committed in the course of the same transaction. Okay, same offense committed in the course of the same transaction. It means if it is stealing, both of them stole. Okay, both of them stole. So they committed the same offense, which is there are two thieves. They went to the same house. They stole things in that same house. So it is same offense committed in the same transaction. It must be same transaction, similar transaction. And that therefore means if Peter is stealing in Kitale and Michael is stealing in Garissa, you can't bring those two together. That is not similar transaction. They're stealing in different places. So all of them must have stolen same house, same date, around the same time. Okay, that is the first one. So persons that are accused of committing the same offense in the course of the same transaction. Same offense, same transaction. The next one is D. I want us to go to D so that it makes sense to you. So we've done this. Let me highlight it. Now we are going to this. Okay, we are going to D. What is D saying? D talks about, before you get to D, let's go back to A. A, same offense, same transaction. Now D talks about different offenses, same transaction. It means they were together and they committed different offenses. Okay, if it was a sexual offense, the person that was sexually assaulted by Peter is not the same person that was sexually assaulted by John. So they committed different offenses, but in the same place at the same time, same transaction. If they were robbing, while someone was stealing, another person was committing a sexual offense. You'll see such things in the exam where robbers will come into the house, and then as some of them are tying up things they're stealing, and one of them or two of them are committing a sexual offense or rape in the back end of the house. So there is different offenses, but they are committed in the course of the same transaction. It means while you are doing this, while this person was doing this, the other person did this. So they committed different offenses in the course of the same transaction. The next one is a person or persons accused of an offense and the persons accused of abetting that offense. Okay? Aiding and abetting. So if I am going to commit murder and you aid me to commit that murder, then all of us, we are going to be facing the same charge sheet or the same information. Okay? Aiding and abetting. Okay? So my offense is aiding and abetting. Your offense is committing the actual offense. So those are people that must be charged together. Okay? They must be charged together. So they must be joined together. Okay? Persons. Let me highlight that for you. All right. That is persons accused of an offense and persons accused of abetting or aiding that offense. If somebody wanted to commit suicide and you are encouraging them, you're telling them, life has been tough on you, maybe it's God's wish that you go early, life has been, come on, you will go to jail and life will be very tough for you in jail. So don't abet or encourage suicide, okay? Don't even try. When somebody is facing a hard time, you be there for them. Don't give them those lectures. Right, together. So if you aid and abet, you are also going to appear. You will be cited as a footnote in that charge sheet. Okay? C talks about persons accused of more offenses than one of the same kind. That is to say, offenses punishable with the same amount of punishment under the same section of the Penal Code or any other act of law committed by them jointly within a period of 12 months. So if you commit a similar offense within a period of 12 months jointly, then you will be, both of you will be facing the same charge sheet. But generally, the most rampant ones are the ones that I've highlighted. Okay? Which is a person committing the same offense or two people committing the same offense in the course of the same transaction, or different offenses in the same transaction, and then aiding and abetting. Are we together? Aiding and abetting. All right, now let us go. Are we together, guys? Confirm we're together before I go back to the charge sheet quickly.
Yes, we are.
Okay, so let us go back to the charge sheet. I can stop sharing and then I can share again. So this is our charge sheet. This is our charge sheet. So our charge sheet has Michael alone. Let us now bring Peter. Okay, so we have the second person, Peter. So how are we going to have a charge sheet? So number one, there could be just one count. Having two people in the same offense, in the same charge, doesn't mean that they committed the same offense. I mean, they committed different offenses. There could be just one count. Okay, there could be just one count. Are we together? So guys, as I'm trying to explain this, please be very keen and note down some things so that once I'm done, you can ask questions so that it becomes clear, because I'm very sure some of you do not become clear on the go. So Just take notes and then ask. Okay. Now, how do we put the jointer there? Now, for jointer of counts, tulisema, jointer of counts, we write count 1, count 2, count 3. That is jointer of counts. Now, when it comes to jointer of persons now, jointer of accused persons, how do we do that? Now, we come to the particulars and then we number them. Okay. Number 1, we are going to say 1, Michael. Okay. And then we are going to say 2, Peter. Okay. On, let me just highlight that for you in green as well. Okay, let's have it. Let me do away that one. So we're going to have 1, Michael, 2, Peter. On the 21st day of December 2021 at Rongai Estate, you stole an HP. So you simply join, you show the jointer by just having them there, 1 and 2. If they're 10, you list all of them. 1, Peter, 2, this, 3, this, 4, this, 5, this. Okay, so 1, Michael, 2, Peter. Okay, on this day at this time, so nothing really changes. You just including them in the particulars because the particulars must include the name of the people. Okay, so that is count 1. So you ask yourself, number 1, if it is only one offense, guys, let me remove this. Let me take it out. Okay, and then let me also take this out. Thanks. Guys, if it is just one offense that they committed together, then our charge sheet will just look like that. Statement of offense, and then particulars. As simple as that, okay? As simple as that. That is, they committed just one offense together. Like I've said, it doesn't have to be that they committed more than, if they're more than one, they committed more than one offense. No, they could have just committed one offense, or it could just be robbery. They were involved in robbery. So robbery, contrary to section 295, as read together with 296(2) of the Penal Code. Okay. Number 1, Michael Peter, on the 21st day of December 2021 at Rongai Estate, while in the company of each other, you robbed an HP laptop belonging to Susan. Are you together? So that is for them. So 1, Michael, and 2, Peter, that indicates the joinder. So the 2 of them in the same charge sheet. Okay, so these people have committed the same offense. Remember our grounds. What was our ground? That they have committed the same offense in the same transaction. So this is the first one. This is the first point. Remember, under 136, we are reading points. There are 3. The first one was people that have committed the same offense in the same transaction. So this is how that charge sheet will appear. Okay, 1, 2, Peter. Now, what if we go to D? What was D saying? D was saying, 136D was saying, they have committed different offenses. Okay, they have committed different offenses in the same transaction. So different offenses. Now, when they have committed different offenses in the same transaction, that tells you, number 1, there is joint of counts. It means there's now more than one offense committed. So there's joint of counts as well as there is joint of persons. So each person is going to be charged in their own count. Okay, so let's assume. Let me bring back the whatever I removed. So we are going to have joint of counts. So the first offense is stealing. So they all committed stealing. Or let's say it is only Peter that committed stealing. Okay, it is only Peter that stole. So Peter will remain in the first count. So anybody can be in the first count. It doesn't matter. You can have Peter or Michael. So the first count, stealing, was committed by Peter alone. At the same time that Peter was stealing, Michael was assaulting. So Michael is the one responsible for assault. So we come to count 2. Now count 2 is only for Michael. Michael, on this day at this time, you assaulted this person. So again, we have joinder of counts there because we have count 1 and count 2. At the same time, we have joinder of persons. Why? Because if you read our charge sheet, you can see 2 people there. 1 in count 1 and 1 in count 2. And I've said they can either be charged jointly or separately. What is the meaning of that? Jointly, it means water in the same particulars. They committed one offense, same offense, jointly. Separately is count 1, kila mtu na count yake. Okay, kila mtu count yake. Count 1, Peter. Count 2, Michael. So that is joinder of counts when they commit different offenses under the same transaction. And that also applies in an instance where they have committed, one has committed aiding and abetting. So if one committed aiding and abetting, what will you do? Aiding and abetting. If one committed the offense, another committed aiding. Okay, for instance, so if Peter committed stealing, so Peter will be count 1, stealing, and then Michael aided Peter, so we'll have aiding and abetting, a felony. Okay, under the statement of offense, aiding and abetting a felony, count 2, and then the particulars will be Michael, on this day at this time, you aided or you assisted Peter to commit this offense. So you get what I'm saying? So that is how we join counts and how we join people. Joinder of counts and joinder of persons. Okay. Now, something I will mention in an exam, you will find even 5 people. Okay, you will find 5 people and you'll find more than one offense. 5 offenses, 5 people. Okay, and you're going to find that when it comes to robbery, all of them committed robbery. When it comes to assault, only 2 of them committed assault. When it comes to rape, only 1 of them committed rape. Okay. Now, in that instance, how are you supposed to come out of that safe? How do you ensure that you come out of that safe? This is what you do. I've told you, the first thing you have to do is identify all offenses in that question. Start by robbery. Okay. You go to rape. You go to assault. And then maybe you go to handling stolen property. Okay, handling stolen. This is a common one. Handling stolen property. So from the way you've read the question, you can see 4 offenses. You'll say fine. That means we have 4 counts. Okay. Once you read 4 offenses, you'll be saying ndio tuko na 4 counts. So you already know count 1, count 2, count 3 up to count 4. The next thing you need to know now is who committed these 4 counts. So you will go back to the question and read under robbery, who committed robbery? And then you'll be finding under robbery, we have Peter, maybe all of them, there were 4. So Peter, Michael, Andrew, and James. All of them committed offense of robbery. So when you come to your count 1, all of them, Peter, Michael, James, John, on this day at this time, while in the company of each other and while armed with dangerous weapon, you robbed this from this person. That is count 1, done. Okay. Number 2, you go to rape and ask yourself, out of these 4 people, who committed rape? And then you realize, oh, for rape, it is only John. So you come to your charge sheet. Count 2, rape, contrary to section 3 of the Sexual Offences Act. Okay. And who is the culprit? John. On the 21st day of December 2021, you caused whatever they caused. Okay. You are done with rape. And then you come to assault. So when you come to assault, you go again to the question and ask yourself, who committed assault here? And then you realize that for assault, it was Peter and John. Okay. So again, you know, count 3, assault causing grievous bodily harm. Contrary to section 234 of the Penal Code, who are the culprits? Peter, 1, 2, John, 3, James. On this day at this time, you assaulted this person. And then you come to handling stolen property. And then you realize that handling stolen property, maybe it could be another person, a different person. another Stephen somewhere. Okay, Stephen. So you say count 4, handling stolen goods contrary to section 322 of the penal code. And then you say, Stephen, on the 21st day of December, or it could be a different date, on this day at this time. Okay, while believing the same to be stolen, while believing, remember the actus reus of sorry, the mens rea of handling stolen property. Okay, while believing the same to be stolen, that phone that you're buying, an iPhone 15 Pro Max, you are buying at 4,000. Hey, we will quote for you section 322 of the penal code. Okay, there is no iPhone that is being sold at 4,000. So when somebody sells you that, then as the prosecutor in that matter, I will be quoting gladly while smiling and looking at your face. 322 of the penal code. What does it say? While believing the same to have been stolen, you gladly handled. You know very well there's no iPhone that is going for 4,000, but you're paying 4,000 for an iPhone. So definitely you believe, you knew or ought to have known that the same was stolen. You handled a stolen property, namely, and I will write it in capital and underline, iPhone 15 Pro Max, 15 Pro Max. You'll be going to committee direct with no stopping. So when somebody handles a stolen property, it means, number one, there are two things there. Number one, they have something on them that is stolen. You know, handling a stolen property is a strict liability. Handling stolen property is strict liability. It is not sorry. There's nothing like, oh, so long as you have it on your body, that is strict liability. Okay. So that is the first one. The second one is now the mens rea. What is the mens rea of handling stolen property? You believed or you ought to have known that this thing is stolen. For instance, you know very well that your son is just a hustler. Your son is just a hustler. Okay? Your son is not working anywhere. But when your son comes home every night with the new things, your son is furnishing your house with the new things. Today is bringing this, is bringing an entire couch. Tomorrow is bringing you a mattress that is worth 300,000. Is buying you a television set. You know very well this person is not working anywhere. So in the eyes of the law, you know that those things were stolen, or you ought to have known, and therefore your place is in committee. And if you're female, your place is in Langata Women. You will be there for some time. We shall come and visit you and give you legal aid for free, and give you some small soda and some bread, which you shall not have eaten in 5 years. You know, when you go to jail, the small things make you happy. Soda tu inakufanya ubambika vibaya sana. Tutakuletea hiyo soda huku kamiti na legal aid. So stop playing. Don't handle stolen property. Buy things from the shop. Go to the shop, sign a contract, and buy your things. Stop buying things from people that you don't know. So, guys, that is how you handle questions of many people and many offenses. Number one, don't start with people. Start with offenses, because those are the counts. And then people will be existing under the counts, under the particulars. Tuko sawa? Everything clear?
Yes, Mwalimu.
All right. That is how you handle the question to do with what do we call it? To do with joinder of persons. So once we're done with joinders now, I want us to go and talk about alternatives. Now, oh Jesus, time is up. But let's talk about alternatives. Alternatives. So an alternative charge, I'm going to be very quick. An alternative charge is now, you are not sure. Okay, I'll give you an example. Something is stolen, okay? Something is stolen in KSL. Let's say at maybe one of the hostels in KSL, okay? Or Gate C. Someone went drinking at Gate C, and then something was stolen from them. Okay, maybe a jacket or a suit. Okay, so this person that stole this thing, or after stealing, of course, they have reported that my jacket, my suit was stolen at Gate C. So the police is searching for this suit. Now, if you're found putting on this suit, okay, there are two things. If you're found putting on this suit, there are two things. The same way, if you're found with a stolen phone, there are two things. Okay, what is the first thing? You're the one who stole it. Wewe ndio mwizi. Lakini kama wewe si mwizi, you might have bought it from somebody who stole it. So it is either you stole it or you are handling. But we don't know. We didn't see you. Okay? What we know is that tumekupata nayo. Okay? So chances are wewe ndio uliiba, ndio maana uko nayo. Okay? Some people are very funny. Very, very funny people. They will steal something and then they'll work with it. You know, when your grandmother who is dead doesn't want you to prosper in life, they first make you to steal and then they make you to put on whatever you've stolen. That is the quickest way of your villagers dealing with you. Okay? I don't know. There are a lot of cases. Even the Delamere's case, where somebody killed. You remember the story of Delamere's? Somebody killed someone. And then the same clothes that the deceased person was putting on when he was killed is the same clothes that this person is still putting on. You know, sometimes even the devil is sitting in hell, wherever the hell is, and the devil is saying, this one is not my son. This one is not my son. You know, even the devil is wondering, which world are you coming from? But anyway, so in that scenario, if you are found having a stolen property, then unless we are very sure, because remember, alternative comes when we are not sure. Okay? Even in marriages, you only have an alternative if you're not sure. Eh? Kama unaona huyu jamaa leti shangwe, kuna place achangamke vizuri. Sasa macha nitafute alternatives. Hii kianguka naingia hii ingine. So alternatives only come when you're not sure. Eh? So that is alternatives. So we only have alternatives when you're not sure of the main charge. So in this instance, we don't know whether you're the one who stole the suit from KSL or you just bought it from someone. So because we don't know or we are not sure, we will charge you with both of them. Okay? But one in the alternative. So the main one will be the serious offense, which is stealing. So remember, let me just do away with this. Okay? And then do away with this so that you can see it better. So the main one is stealing. Okay? But we are not sure. We are not sure whether you actually stole it. So we are going to add something so that if one day the real thief comes out, okay, if there's evidence that you didn't steal it, then we shall still capture you under the alternative. So we are going to say alternative. Let me control V. Yeah. So alternative charge. We're just going to write alternative charge. What is happening to my? Yes, alternative charge. So just write alternative charge. Okay. I'll show you when there's a count also so that you see. So alternative charge, the same thing. Statement and copy. Let's have it there. Statement of the offense, alternative charge. So the main offense and the alternative. Okay, that is where we are not sure. So main offense, alternative. So what is our alternative? Let's say handling stolen property. Sorry guys, I know I'm keeping you guys from sleeping, but I had to explain this. Contrary to section 322 of the Penal Code. This is my favorite section of the Penal Code. My all-time favorite is section 322. Yes, so I like 322. My favorite. So section 322 of the penal code. Okay, that is a statement of offense. And then we are going to have the particulars of the offense. Okay, the particulars of the offense. So copy that, again, bring it there. And then particulars of offense at that place again. I remember that this one doesn't have to be same day. It could be maybe the 28th. Let's say 23rd. Okay, it doesn't have to be the same day, but remember, it is the same transaction. So the first day, we are assuming that you stole it on 21st. But if that is not you, fine. We are going to charge you with handling because tumekupata na hii. So Peter, on the 21st day of that, you handled or state having information to believe I like quoting this section. Having information to believe that the same was stolen. You know, when you just buy things like you found a cheaper one, you're buying, my friend, tis. The same was stolen. You handled stolen goods, namely, an iPhone. Okay, an iPhone 15 Pro what? Pro Max. Okay, by retaining. I will explain later what I mean by retaining. Remember, under 322, there are different ways of handling. Handling could mean you receiving. When you receive a stolen thing, that is handling. When you retain it, it is handling. When you store it for someone, that is handling. When you sell it, it is handling. Okay, so you have to identify exactly how they handle. So you handle by retaining. So you have it, you received it and you are still having it. Okay, so that is how you do that. So that is how you input. Okay, that is how you input that alternative count. And then you just come and date and sign. Tuko sawa? Somebody just give me a thumbs up if you're fine. I'm rushing so that we can close. Okay. All right. Perfect. Now, having looked at this, okay, that is how you bring that. But now let's try again and look at this in the context of, just give me in the context of counting, where there are different counts. So I'm just going to bring that back. Oh, damn it. I didn't. So let me copy this. Let's see. Let me copy this. Let me now bring the counts back. Let me bring the counts back. Yes. So that is count 1. And this is count 2. So just bear with me for a minute. Count 1. Okay. Now, assuming that now count 1 here is the one that has an alternative, but count 2 doesn't. Okay. How are we going to handle that? So we are going to write count 1, stealing, contrary to section that of the penal code. Okay. And then we are going to come before count 2, just before count 2, we are going to come there and insert alternative to count 1. Alternative to count 1. Okay? We have our alternative to count 1 there, which is this. Let me highlight it for you. That is the alternative to count 1. Okay? And then count 2. So count 1, count 2. No, count 1, its alternative, and then count 2. Now, if count 2 also has an alternative, then we shall go and write alternative to count 2. Same thing, statement of offense and particulars of offense. Now, they must be, I think I will teach alternative charges in the next class because there's something you need to understand about that. So alternative charge, like I've said, it is when you are not sure of which one. But remember, the alternative count must be inferior to the main count, but also they must be related. You can't say main offense, stealing, alternative, rape. No, those things are not related. They should come from the same fact. Okay? They should come from the same fact. In terms of rape, for instance, okay? If we are not sure whether you actually raped, committed the offense of rape, or it was just a sexual indecent assault, then we'll be saying, fine, we're not really sure whether there was penetration, the aspect of penetration, but lack of penetration gives us indecent assault. So we will charge you with rape, but in case we can't show rape, we will show indecent assault, which we already have. So rape is the main one. Alternative to rape is indecent assault. Okay? That will be the question. Don't worry. The examiner will let you know alternatives when there's an alternative. Okay? You'll be told maybe the DPP is considering an alternative charge. Okay? So it must be related. If murder and manslaughter were being charged together, then murder will be the main charge. Manslaughter will be alternative. So that if we don't prove the mens rea in murder, we will have the actus reus of manslaughter. But remember, for murder and manslaughter, the law under the CPC allows the court to presume once the actus reus has been proved without the mens rea, the court will just convict you of manslaughter without you being charged of manslaughter. Even in these others, you don't have to have an alternative because the court, once you prove the actus reus, then the court will proceed and convict you. But in most instances, parties will still have the alternative. So I want us to stop there. In the next class, I will expound further on what I've just said, but also we will look at now the defects in the preparation of a charge sheet, the defects in preparing a charge sheet. We will look at what are the problems, how do you correct a defects? So either motion to amend the charge sheet, an application to amend the charge sheet, and then a motion to quash, which is to strike out the charge sheet because it is duplicitous, it is not properly drafted, and then that is that. So kindly, guys, that is, I want us to stop there because of time. I think I've taken a lot of time. So drafting of charges is not that hard. It's not that hard. Okay, so please, please, please don't complicate things. Don't complicate your issues. Please just keep it as simple as it can be. Okay, please keep it as simple as it can be. Go sour. So these are actual alternatives. I need to. Oh, we have a lot of them here. All right, guys, are we together?
Yes, Mwalimu.
Okay, then if we are together, then that is fine. That is fine, fine, fine. Very fine indeed. Thank you very much indeed. All right, any question? I think I will meet you guys tomorrow for commercial, but if there's any question right now that I should tackle, again, guys, this one takes practice. You need just to practice a little bit, and then you'll be fine. Let us start from the lady from Ruiru, Joy wa Ruiru.
Okay, thank you.
I wanted to ask about overt acts and how to write them.
What do you mean overt act? That's a big word.
Yes, I came across it and I didn't know how to address it.
What is an overt act according to you?
It is an act that I thought it worked like an alternative charge, but I stand guided.
No, don't stand guided. You know, when talk about overt, it's just an English word. Okay, so if you talk about an overt act, the meaning of the word overt, unless there's something hidden, I'm not picking, but the meaning of the word overt is something that is really open. When something is done openly, it means you're overtly being committing the crime. You're doing it openly. So unless I'm not getting the content or the context of the question, when you say an overt act, something overt is something done unconcealingly, done visibly, done openly. So I do not know what you'd categorize as an overt act in this context, but we can all look into it and then we can try looking at that question. You can share it with me and then we can find a response to that. And that's okay.
Yes, thank you.
We have Kamiriwa. Kamiriwa. I don't know why. I'm just saying this as a by the way, it's not something serious. But I've just noted, I was just doing I've noted that you guys not you guys, I mean, people from the mountain, you like your professions coming last. Like in other places we'll be saying Dr. Michael, Dr. James, you know. But when it comes to you guys, it is usually the name first and then the profession. Yoroa Uba, Emmanuel, something. I don't know, maybe it's something special to you guys. Okay. I know Murima, hatufai kuguza Murima. Sawa sawa. Kamau wa moshari. Huh? I don't know why you guys always have it like that. Sawa sawa. Let's have Rachel. Or no, Kamiri John was first. Kamiri wa Weni Kamiri wa Shylock.
Kamiri wa kuhaso.
All right, Kamiri. Talk to us.
No, I just wanted to just to add to my sister Waroiro that when you talk of an overt crime, this is as you have said from the term of overt. It is any crime which does not require much explanation. It is so clear that by the evidence which is adduced, you do not need to bring about the mens rea. The actus rea was so clear, and there is no debate on whether you committed that crime or not.
That is amazing. Thank you so much, Kamiri. So what we are going to do actually, we are going to let's get a case on that, a case or two, and a few examples, and we start with that in the next class. Thank you so much, Kamiri wa Shylock. Kamiri, by the way, is a Shylock guy, so if you guys want Shylock money, you can look for Kamiri. But I will warn you, Shylocks are not good people. But if you want money, look for Kamiri. All right, Rachel.
Yes, hello. You were meant to show us an example of an application for remand by court.
We did that in the last class. Were you there?
I was in the last class. We were supposed to do an assignment draft, and then you were supposed to show us an example. If I believe so, you did not show us an example.
Did you do the assignment yourself?
I attempted. An attempt was made.
Did you share it with me?
No, not yet.
No, the window is already closed. All right, so I've noted that we'll make that in the next class. Somebody else, guys, again, go through what we discussed today. I'm going to try. I usually forget. I have a lot of things in my mind, but I forget to share these templates. I'm going to share this one right now in the chat, just right away, so that you guys can go through the few things we've talked about and see. Try and drafting your own and look at past paper questions and see whether you can make sense of those things. Tuko sawa? Otherwise, mimi nawaombea sana mkuwe na maisha marefu sana na